morning, Your Honors. May I please the court?
You want to reserve any time, sir?
Yes, sir. 3 minutes, if I could.
3 minutes. You got them, and you may begin, sir.
Thank you. My name is Jose Garcia, and I represent the appellant, Ms. Patricia Granados, in this case. And basically, Ms. Granados respectfully requests this court to overturn an order that dismissed her case for committing fraud upon the court.
I'm not sure that I could understand from your brief the standard of review. You seem to take a couple different positions on the standard of review. Would you tell me what you think the standard of review of such an order is? Yes, sir. And the standard review, it will be a de novo review. It will be the trial court. It will be if it's based upon the record. Why in your brief did you make an argument that perhaps it was not a de novo review? That I made an argument that perhaps it was not a de novo review, Your Honor. I am not aware that I made that argument. If it's okay.
Counsel, excuse me, but I thought that the standard of review was abuse of discretion, but a narrowed abuse of discretion.
Yes, Your Honor.
Something that I'm not entirely sure I understand.
And you understand that's different than de novo.
Yes, Your Honor, and it is an abuse of discretion. And Your Honor, I think that the rule was stated by this court in the case of Cutts versus Burke, that the trial court, in order to sustain a motion to dismiss for fraud upon the court, that there has to be a very stringent standard. There has to be a clear and convincing evidence on the record that the party engaged in some type of cognitive or affirmative action in order to defraud the court or to.
You don't think that in this case her answers were not in that category? No. I mean, when she said one of the key or one of the main things you search for in a case like this is prior injuries, and she says, I had no prior treatment for chronic back pain or headaches. And apparently that wasn't truthful.
Well, Your Honor, the answers, first, she presented answers in her interrogatories. She disclosed the doctor that treated her in her interrogatories. Basically, in the affidavit, she explained that the previous treatment that she had obtained from that doctor, which was a year before the accident, arose because she had a family history of cancer. She believed that she was ill at that time. She suffered from pain in her back. She had headaches. She had a sore throat. She had numerous symptoms, and she went to the doctor because of those symptoms, not because of back pain or neck pain or headaches, but because she was feeling ill. The doctor made a diagnostic, and this was on November 26th of 2000.
So your position is she just misunderstood the question?
No, Your Honor. In my position is that in her mind, the treatment that she obtained from the doctor was totally unrelated to anything that was trauma caused. You got to understand that in this case, she went for treatment after the accident because of the symptoms that she was incurring or that she developed as a result of the collision. Prior to that, the only time that she went to the doctor, that she went to receive treatment, is because she felt ill. She felt, and what the doctor diagnosed her or found was that she was suffering from a urinary tract infection. She was given antibiotics for that. She came a month later. She had a follow-up appointment with the doctor. She felt better. It's documented in the record.
Her deposition was never taken in this case, was it?
Her deposition was taken, and one of the problematic issues with
she was not asked. I'm sorry, I misspoke. Was she asked specifically about prior treatment?
She was not. She was asked what doctors she was treated before, but she was not asked specific or questions about her treatment. She was not asked those fundamental questions that are necessary to show that she had a cognitive awareness that she was going to defraud the court. For example, she was not asked whether or not she previously had experienced neck pain. She was not asked whether or not she had previously experienced back pain, or she sought treatment for those things. She was never asked those fundamental questions, and as a matter of fact, she was not asked whether she had received previous diagnostic testing, such as X-rays or MRIs. whether she had received previous medical treatment for all of the symptoms that arose after. And it is very important also that the records that she disclosed, that the records were obtained because she disclosed the treating physicians in this case. And the treating physician who provided care to her immediately after the accident, in his intake form, in his intake sheet, he basically, she disclosed to him that she had pre-existing conditions, that she had previously treated or that she had back pain before and headaches before. So those things were disclosed in the records, and the records that defense counsel was able to obtain because of her disclosure.
Now, you note a couple times in your brief the length of the hearing. What relevancy did that have?
Your Honor, it is the persuasion of, or what happened at the hearing, Your Honor, was that when we arrived at the hearing, we had requested the transcript of the deposition of Dr. Amador prior to the hearing. We did not receive it. When we arrived at the hearing, the court reporter handed us the transcript to the deposition of Dr. Amador. I mean, literally when...
You were there. You were present for the deposition.
Yes, sir. Yes, sir. But
what relevancy did the length of the hearing have?
Your Honor, I do not believe that I was able to basically present my case. Period. When opposing counsel stood up,
And is that an issue that you've preserved for appeal?
Your Honor,
Go ahead. I'm sorry.
Yeah, I was just trying to basically show the court what had occurred at the hearing. That it just the time constraints that we had in presenting or in looking at the deposition transcript of Dr. Amador was very short. In this particular case, the opposing counsel was the person who argued Brown versus Allstate before the court. His initial arguments to the court was, I argue Brown versus Allstate, and at that time, I believe that the argument was shut, and I was not able to present the evidence. I believe that would show that she did not make a cognitive decision to perpetrate a fraud upon the court. It's very important.
Mr. Garcia, as I look at the standard of review, it is something called an abuse of discretion, but a narrowed abuse of discretion. What do you think that means?
Your Honor, I believe that what that means is that this court will look to see whether the trial court basically looked at the evidence in this particular case, and that it would be confined to the record. Understand that this court.
I don't know that that's any different than any other abuse of discretion.
Well, I understand that this court in this particular case would be able to look at the entirety of the record, and because the decision was made on the record, that it will be given, or that the trial court will be given a little bit less deference than in most cases where abuse of discretion is the standard.
Ms. Wheeler, you might take note of that question because you're going to get it too.
And in this particular case, Ms. Granados also filed an affidavit in opposition to the motion to dismiss. That affidavit that she filed was the first time that she was able to explain her previous treatment. She was not asked the questions about her previous treatment at deposition. So in order to oppose the motion to dismiss, she filed an affidavit, and she explained what the reason that she had obtained previous treatment. It wasn't because she had suffered trauma. It wasn't because she had a previous injury that was undisclosed. It was because she was ill, that she had an urinary tract infection, and she had a number of symptoms that were pain related, and that's why she obtained treatment. And with that, thank you, Your Honor.
So, Ms. Wheeler, what the heck does narrowed mean?
Your Honor, I think what it means, I think it's been applied in cases of this type where perhaps there was not an evidentiary hearing that was held in the trial court, and because there was no evidentiary hearing, the trial court was not able to see and observe the witnesses. I think that when there's an evidentiary hearing, that the trial court's discretion, if you want to call it, is heightened as opposed to narrowed, because the trial court then, in that sense, does have the opportunity to see the people, to make observations about their credibility.
Was there testimony taken at this hearing?
No, Your Honor. There was.
So we do apply the narrowed standard here.
If you want to call it that, and I think maybe that means that the appellate court has the opportunity to review the same materials that the trial court did. But by the same token, Your Honor, last week I filed a notice of supplemental authority and filed with the court a recent decision out of this court.
We've seen that. We've received that. Isn't dismissal in these cases limited to the most egregious of situations? Isn't that what the cases throughout the state talk about?
I don't think it is, Your Honor. I think the whole...
Don't we want people to have their day in court as a general proposition?
I think we do, until they abuse the system. And the Cox case goes back and talks about it in terms of weighing the policy of allowing cases to go forward. And,
you know how many cases use that phrase, egregious? Have you not come across that in reading and reviewing the case law in this area?
I have come across it, but Your Honor, I honestly haven't tallied them up to say how many say it and how many don't. I cannot tell you that. I'd be happy.
You took the deposition of the plaintiff in the case. Was the plaintiff or the appellant ever specifically asked whether she had previously been treated for back and neck injuries? A pretty simple, straightforward question.
I don't think that question was asked, Your Honor, on the deposition, but in the interrogatories that were sent to her, and Mr. Garcia attached a copy of the interrogatories to his brief. Interrogatory number 26, with respect to any injuries or symptoms described in your answer to interrogatory 11, please state whether you at any other time ever had any similar injury.
We read the record. But the point is that you had an opportunity at deposition to ask a very simple question that's asked routinely in personal injury cases. Have you ever previously been treated? She was complaining of neck injuries, complaining of back injuries. Were you ever previously treated for any neck or back injuries? And then if the person is dishonest or untruthful and hides information, it seems to me that you have a stronger argument.
But, Your Honor, the rest of the question that I was trying to read says, have you ever had similar symptoms of the same or similar area of your body? And here, it's not whether she was treated before. She said, I have these problems now. I have neck, back, I have headaches. She said, that's what I'm claiming as a result of this accident.
But you have cross-examination. That's what cross-examination is for.
I understand, Your Honor, but how many times does the question have to be asked? Well, if she was asked that on her interrogatories, she signed before a notary public, said, I swear this is true, and what she said in answer to interrogatory 26 was not applicable. Now, does that mean that if you lie once, you're excused, but if you lie twice, you're not, or 3 times, you're not? How many times do you have to lie in a legal proceeding to be perceived as taking advantage of it?
Ms. Wheeler, how was your defense hampered as a result of that interrogatory answer? And I guess the interrogatory answer is the only time we're talking about here, right? It is
well, there were some questions in her deposition, because she was asked the straightforward question in her deposition, have you ever been seen at Florida Hospital Altamont? And she said, well, I went there for a mammogram and for a colonoscopy. She had been at Florida Hospital Altamont for that x-ray of her low back when she was sent there by Dr. Amador less than a year before this accident.
She disclosed Dr. Amador, right?
She disclosed him. If you look at her answer to interrogatory, she said, I've seen these doctors for the accident, and then down in a separate thing, I've seen these doctors in the past 10 years, and she did not list him there. So had the defense defense counsel not gone and gotten records from Dr. Amador, but...
Well, hold on for just a minute. Did she disclose Dr. Amador during the deposition?
Your Honor, I honestly don't know at this point. I think she did.
You'll find she did.
I think she did.
So how was the defense hampered?
In this particular case, Your Honor, this is a lady who moved to this country from Colombia in the year 2000. This accident happened in 2004. We don't have, there's just not the same opportunity that a defendant has with respect to someone who's been here longer. There's not, I don't know how familiar...
That's a novel argument.
Well, but Your Honor, does this mean that if someone comes from another country, they can just lie with impunity?
No, but here you had the name of the doctor. All you had to do was, as soon as you took Dr. Amador's deposition, you knew that she'd had the headaches apparently related to this bladder infection.
Well, she had, but the part of the problem was, Your Honor, Dr. Amador had her fill out a questionnaire on that first visit in November of 2003. And on that questionnaire, which is in the record, she says that she had previously had migraine headaches. Twice, in fact, she indicated that she had previously had headaches. She also told Dr. Amador that she'd previously had low back pain. So that's all we have, is just, we've got that questionnaire, we've got the information from Dr. Amador, and we don't know if she went to some other physician.
You never asked her on deposition about that.
Well, again, Your Honor, I don't know how many times you have to ask the question before it becomes fraud.
The problem is we're looking at a standard that says that it has to be an egregious abuse. And I'm trying to find where is the egregious nature of this. If she discloses the doctor, and you know, all the information about her headaches and low back comes out from there, how is that egregious?
Your Honor, she disclosed one doctor, Dr. Amador. She did not disclose any physician, any healthcare provider, any hospital that she went to in Colombia. She was asked the question in her interrogatories, and she did not answer it.
Do we know whether there were any?
Pardon?
Do we know whether she saw
No,
any?
I don't. How do we find out, Your Honor?
She wasn't lying.
Well, I don't know, but I don't know, but
we can't presume that she was lying about her medical
except
history.
for the fact that we know that she had headaches in the past.
Did you ask her who her treating physicians were?
Your Honor, I was not the person who took the deposition.
She was not asked those questions.
I don't think she was. But I guess that means that that a defendant should never be entitled to take a plaintiff at their word for the information that's provided in the interrogatories.
Well, you characterize it as a lie. I know that the appellant certainly would not agree with that characterization. And again, I go back to one of my opening questions to you, which is that the law favors giving people their day in court, and dismissal is the most severe of sanctions that can be imposed upon an individual. And so as a result of that, the courts are very clear that only the most egregious of cases where people are hiding the type of medical records or conduct that really goes to the heart of the defense in the case, that those are the types of cases that dismissal is appropriate.
Your Honor,
don't you think that there's some inquiry necessary?
Well, there was inquiry made, Your Honor, and it was not truthful. And I would take issue with the fact that I agree the plaintiff is entitled to her day in court, but so is the defendant. And, Your Honor, a jury can only weigh evidence if it has evidence to weigh. And where are we supposed to get information about a plaintiff's past medical history other than the best source of that information, which is the plaintiff herself? And if she's not willing to be forthright and forthcoming about that past medical history, Your Honor, even after...
She gave you the name of the doctor, and you went and subpoenaed those records, as is done in every one of these cases, and you learned everything about her treatment that you need to know?
We learned everything that that doctor knows, Your Honor. We did not learn everything the plaintiff knows. We learned that she had a history of low back pain. We learned that she had been not only to Dr. Amador, but went to the Florida Hospital in Altamont Springs, where she had a low back x-ray, which was interpreted as showing scoliosis and degenerative changes, and we know that Dr. Amador diagnosed her with arthritis. And even after she had that information, before the hearing on the motion to dismiss, she filed an affidavit saying he was wrong. She filed an affidavit saying the x-ray didn't show anything. She filed an affidavit saying, I didn't go in there for my back. Well, maybe she didn't go in there for her back, but when she got there, she complained about her back, and she complained about it enough that the doctor sent her for an x-ray. Those facts can't be changed, and this is what we've been able to find out. And again, she saw Dr. Amador in 2003, 3 years after she moved here from Colombia. And as I said, whether she saw another doctor in Colombia, we have the interrogatories asked, and these are the approved standard form interrogatories.
Dismissal should stand because there might be other information that you don't know about.
Well, we know that she didn't provide some information. We know that she was not truthful on her interrogatories. Does that not give rise to an inference that maybe there's something else out there?
But that's not enough. Because
how do you find it, though, Your Honor?
Counsel, don't you have to prove that there was fraud by clear and convincing evidence?
And what else can we do in this case, Your Honor? Do we just allow
I think the answer might be that there's nothing else you can do, and this should be reversed.
Well, in the Cox case, Your Honor, I think the statement was very telling, because there was a lot that the defendant was able to uncover in the Cox case, and the statement was we don't know what they were not able to find.
Well, I'm looking at Gehrman, where we concluded in a very, very similar case. This is a case where allegations of inconsistency, non-disclosure, even falseness can be brought to the jury's attention through cross-examination or impeachment.
But, Your Honor, in the Gehrman case, I would point out to you, Your Honor, that in Gehrman, I think there was one instance that was maybe 10 years before the accident where the fellow went to a doctor complaining of back pain, and another instance, I think, 8 years before the accident. What we have here is a situation where this woman went to the doctor a year before the accident, complaining of a history of migraine headaches, complaining of low back pain, received a diagnosis of chronic low back pain and arthritis, and she even said she'd been taking over-the-counter medications. So this was a situation where it was an ongoing problem with this woman, at least by the doctor's own testimony. And this was testimony from the doctor. And the plaintiff never came forward, even after. In Gehrman, I think there was an affidavit where he came forward and he tried to explain it was minor and he didn't even think about it. She has never come forward with any attempt to explain why she lied on her answers to interrogatories, why she failed to reveal in her answers to interrogatories. Perfect opportunity. This is in writing. She has the opportunity to talk to her lawyer in advance, and instead of answering truthfully that interrogatory 26, have you ever had any prior symptoms that in an area similar to what you're claiming here, she says not applicable. And
she says not applicable?
That's what she said.
Do you reckon that might have meant that she didn't have any traumatically induced?
No, because it didn't ask whether you'd ever been injured. It said, have you ever had any symptoms?
I'm confused by that answer, I guess.
Let me see if I can find the question again, Your Honor, so I can read it to you.
Oh, I have it here. It's all right.
It's interrogatory 26, and it is attached in an appendix to their initial brief. There were some questions about the length of the hearing, and I don't think, I reviewed the transcript again, flipping through it. I didn't see that there was any complaint at the hearing about the length of the hearing.
That's a red herring.
Yes. I think that
Say everything you possibly could.
I think I probably have, and unless the court has some more questions, I will stand on my brief and request that you affirm. I think that the standard has been met in this case. Thank you, Your Honors.
Thank you, Your Honor. Going back to interrogatory number 26, I think it's very important for the court to understand our Ms. Granados' thought process at that time. She is asked whether or not she has had similar symptoms in the past, whether she has been treated for similar symptoms in the past. Now,
no, the question, read the interrogatory again. I don't think it talks about treatment. It just talks about symptoms, doesn't it?
Yes, sir. It says here whether or not you have been treated by any doctor or hospital or other healthcare provider for any problems in the same areas of your body before the accident. And then it says for such visit to any doctor or hospital or other healthcare provider, please provide the names and addresses and so forth. And in her mind, it basically, she went to the doctor, and it's in the record, she went on November, a year before the accident. She went for a specific problem that she was feeling. She was feeling awful. That's the reason she went. It was not trauma-based. Now, much is being said about records, or that she went also to the Florida hospital and and that she did not disclose that. When she went to the doctor, Dr. Amador conducted a series of tests to find out exactly what she's complaining. This lady has a family history of cancer.
Symptoms. What do you describe the meaning of that word, symptoms?
Well, Your Honor, in this particular context, is if a person, there can be a distinction between you feeling, or a person feeling the overall symptoms of just pain and general aches that might be produced from a urinary tract infection, that she would be aching all over her body, versus a symptom of sharp pain that is produced by a rear end collision.
Well, the question really is whether she intended to perpetrate a fraud upon the court.
Correct, Your Honor. Correct, Your Honor. And basically, and for that, you have to go to her actions. You have to go to her testimony. The opposing counsel had an opportunity to verify the interrogatories at the deposition and to say...
Counsel, isn't the answer to the question that Judge Cohen asked that the judge is the one who listens to the facts and makes a decision whether it was willful or not?
Yes, Your Honor. And
in this case, apparently that was the case. The judge listened to all of this and made a decision that it was a willful...
Yes, Your Honor. And I will respectfully submit that you need to, or that the court erred. And the reason for that, Your Honor, is that the plaintiff, the party herself, she was deposed. And at that deposition, foundational questions that are necessary to show her intent to perpetrate a fraud upon the court were simply not asked. So the record is vacant as to her intent, whether or not she did. Now, if she would have been asked, have you ever complained of back pain before? And she would have said, no, we might be dealing in a different category, but we are not in that realm because those questions were not asked, Your Honor.
Okay.
Thank you.
Thank you.